Hi, I'm attorney Rachel Mineo with Cervantes Chat and Prince, and today I'm going to discuss with you the case of Ty versus Triumvera 600 Naples Court Condo. This case involved discrimination as well as claims of retaliation and invasion of privacy. Now, this case also piggybacks on the coattails of the U.S. Supreme Court case recently came down, Bostock versus Clayton County. That case involved discrimination based on sexual orientation, and Bob Prince from our office actually did a great summary of how that case can impact association boards. That video can be found on our Facebook page from June 16th of 2020. So if you haven't already watched it, you can go to our Facebook page to view that video and get a summary of how discrimination based on sexual orientation can affect boards. Now, this case specifically dealt with discrimination based on familial status as well as race. It also discussed retaliation and invasion of privacy, which I know are legal terms. So I'm going to try and break down exactly what happened in this case and explain why boards need to be concerned about this, or at least aware of them going forward. Now, in this case involved a unit owner who had 4 small children, and over the course of 2 years, he had had multiple complaints of excessive noise coming from the unit below. Specifically, the unit owner below claimed that the children playing had caused unnecessary and excessive noise, and felt that the unit owner above was not doing enough to soundproof the unit or discipline the children to keep them from making the noise in the first place. Now, of note, the unit owner below was also the board president. Now, in 2017, in early 2017, there was a plumbing issue within the unit where the owners required the association to take action and make repairs. So the association's plumber was actually in the kitchen of the unit to fix the sink. And apparently while he was there, took it upon himself to take photographs of the unit and specifically the kitchen. There were dishes piled in the sink, pots and pans on the counter, as well as boxes piled up within the unit. So he takes these pictures, forwards them to the board president, and from there the association decided to issue violations related to the cleanliness of the unit and also the soundproofing of the flooring. Now, the action taken by the board at that time was limited to violation and fine notices. From there, the unit owner filed a complaint with the IDHR, claiming that the association was discriminating against them based on their familial status as well as their race. And the association was sent a copy of that complaint. Now, the complaint came in late April of 2017, and within a month, the association had changed course, had stopped doing violation and fine notices, and instead initiated litigation against the unit owner based on the cleanliness of the unit as well as the flooring, that the flooring was not sufficiently soundproofed in accordance with the declaration. In turn, the association, the unit owner sued the association, claiming invasion of privacy based on the plumber taking the photographs without being authorized to do so, and also based on violations related to their discrimination and retaliation, because until the association received their complaint, that had not initiated legal proceedings against them. Ultimately, the trial court found in favor of the association on the issues of discrimination as well as retaliation. The case did go to jury trial on the other counts of the complaint, and the unit owner was awarded, a jury did award based on the invasion of privacy. However, the appellate court reversed this decision made by the trial court related to the claims of discrimination and retaliation. And specifically, the appellate court went into a great discussion related to the measures taken by the board and how they were prompted in response to the unit owner's IDHR complaint against them. So what are the takeaways? Specifically, boards need to be very aware of discrimination claims made by unit owners. And in this case, it was even more telling because the initial discrimination was stemming from the actions of the board president himself, and the discrimination that the claims of discrimination based on his noise complaints related to the children specifically. Now, boards need to be very aware when you're making any sort of decisions based on familial status, and specifically when it's based on small children. So what we see a lot of the times is previously there were a lot of rules being made for associations that involved things that were very specific to small children. So things like baby buggies or strollers or toys that you're specifically identifying these families that have small children, and that can be grounds for discrimination because you otherwise would not have these rules. You're singling out a subsect of the population based on their familial status of having small children. So that's something that the association should review. We would recommend that boards review any rules that include those types of subsets of the population to see whether or not they're in compliance in general, but also especially in light of the recent restrictions that HUD has implemented for hostile environments. Now, again, as Bob had discussed with the Bostock case, HUD does have these restrictions that for hostile environments that came down in the past couple of years, that boards have an affirmative duty. If you become aware of harassment or discrimination, a board must take action to not only take action against the offending unit owner related to the previous harassment or discrimination, but also has an affirmative duty to try and implement steps to prevent further harassment and discrimination. Now, in this case, the alleged discrimination was coming from the board president himself, and it's pretty clear from the record that he did have an issue with the small children in the unit. Now, the remaining board members had a duty to independently review the actions, and if they were aware of any discrimination based on familial status, they had the duty to prevent this from happening in the future. Instead, in this case, the board complicitly, agreed to go along with the actions that were being promulgated by the board president, which could very well amount to individual liability against these board owners or these board members. Now, another issue in this case that was discussed at length by the appellate court is the retaliation claim. So essentially, the timeline of events becomes very important when you're talking about a retaliation claim, which is basically that anytime you have a unit owner making a complaint with a professional agency within the state, then to turn around and file suit against them could be viewed as retaliation. Now, in this case, the unit owner did make the claim of discrimination, and it wasn't until after that claim was made that the board did an about face and started legal proceedings instead of trying to handle it in-house that they had done up until they received that IDHR complaint. So anytime you have a unit owner who does initiate a complaint, whether it's with IDHR or with a building court complaint, those need to be, you need to, as a board, evaluate whether or not you should be proceeding with litigation against that same owner, or is it being motivated by the fact that they have filed a complaint against you. Another issue I want to touch on is the invasion of privacy issue. Now, this is something that unfortunately we do deal with on, a fair amount of time. I wouldn't say a regular basis, but it does happen where association vendors are in the process of doing things throughout the association property and they do witness violations. Now, in this case, the association's plumber was only given access to the unit for the sole purpose of conducting a plumbing repair. He then exceeded the scope of why he was there by taking photographs within the unit that he otherwise would not have had access to. So this does constitute an invasion of privacy. And that is something that boards need to be aware of, that to make sure that your vendors are not exceeding the scope of why they're within a unit, and to be very careful of what action you take in response to getting information. You need to be aware of the source of that information and whether or not you would have known about it except for a vendor having limited access. So if you have any issues that arise, whether it's discrimination or a complaint against you or the board, and you are dealing with some of these issues, or a vendor who acts outside the scope of what their access to a unit is, we're certainly happy to answer those questions, or any questions that you may have in general related to your association. So if you have any of those questions, you can certainly feel free to reach out and contact our firm. And until then, stay safe.